This is part 2 of the previous lecture on bail. In that lecture, we discussed bail and bailable offences under section 496 of CrPC. In this part, we are going to discuss bail and non-bailable offences under section 497 of CrPC. Let's first read the section. When any person accused of non-bailable offence is arrested or detained without warrant by an officer in charge of police station or appears or is brought before a court, he may be released on bail. But he shall not be so released if there appears reasonable ground for believing that he has been guilty of an offence punishable with death or imprisonment for life or imprisonment for 10 years. Let's take out the underlined keywords of this subsection 1. The first one is non-bailable offence. The offence must be non-bailable. To find out whether the offence is bailable or not, we should read Schedule 2, Column 5 of CrPC. The second one is the accused be the arrested or detained one without warrant by officer in charge of police station or by other competent authority. Third one is if the accused is not arrested, he himself appears before the court or is brought before the court by officer in charge of police station or by other competent authority. The fourth one is the non-bailable offence not be punishable with death. The fifth one is the non-bailable offence not be punishable with imprisonment for life. The sixth one is the non-bailable offence not be punishable with imprisonment for 10 years. It means that the offence be punishable with less than 10 years of imprisonment. If the court is satisfied with the following 6 points, the accused may be released on bail. The word may has been used by legislature. The word may does not give right of grant of bail to the accused, but it gives discretion to the court. And discretion is not exercised according to like and dislike of the judge, but it is based on judicial principles. Bail is granted in bailable offences is a right, but in non-bailable offences it is granted as grace, concession. But the court shall not release the accused under section 497 if the non-bailable offence is punishable with death, if the non-bailable offence is punishable with imprisonment for life, if the non-bailable offence is punishable with imprisonment for 10 years. Competent criminal courts have discretion to grant bail even in appropriate murder cases, but they are under heavy duty to exercise their discretion fairly, justly and properly to meet the end of justice. Duty of the court while granting bail. These points should be considered by the court while granting bail. The first one is reasonable grounds for believing. The court has to consider reasonable grounds to believe that whether the accused has committed the offence or not. Under subsection 1, the court has to consider reasonable grounds to believe that whether the accused has been guilty of non-bailable offence punishable with death, imprisonment for life, or imprisonment for 10 years or not. Under subsection 2, the court has to consider that whether the case is of further inquiry or not. If the court is satisfied that there are no reasonable grounds to believe that the accused has committed the offence and the case is of further inquiry, the court shall release the accused on executing bond without sureties for his appearance in the court. Under subsection 4, when the trial of the accused is concluded but the judgment is not delivered, at any time when the court is satisfied that there are reasonable grounds before the court to believe that the accused is not guilty of the offence with which he is charged, it shall release the accused on executing a bond for his appearance in the court to hear the judgment. The second one is a case of further inquiry, which we have already discussed under subsection 2. The third one is a case of minor, woman, sick, or infirm person, which we discuss under first proviso of subsection 1 of section 497. Under this proviso, any person under the age of 16 years, or any woman, or any sick or infirm old person who is accused of an offence punishable with death or imprisonment for life or imprisonment for 10 years, the court may release him or her on bail. Court can take evidence about age or sickness or infirmity like birth certificate, medical certificate of an authorized medical officer. Minority is not sufficient to entitle the accused to claim bail as of right where the age is disputed or the certificate is forged document. Accused woman is entitled to be released on bail under this proviso if she is in jail and no more required for investigation, a woman in advanced stage of pregnancy, a female carrying suckling baby, or a woman with children aged 2 months to 2 years is entitled to be granted bail. Now, sick person. If the sickness which the accused is suffering from is such that it cannot be properly treated within the jail premises and some specialized treatment is needed, and his detention in jail is likely to affect his capacity and dangerous for his life. Infirm person. Infirm means sick and old person who needs special care, who is also entitled to be granted bail. Now come to the points again. The fourth one which the court has to consider is nature and gravity of the offence with which the accused is charged. The fifth one is the severity or degree of the punishment in case of conviction of the accused. The sixth one is the court has to consider the danger of absconding of the accused if he is released on bail. The seventh one is the danger of witnesses being tampered with by the accused if he is released on bail. He may threat the prosecution witnesses. The eighth one is the danger of the offence being continued or repeated by the accused if he is released on bail. The ninth one is the character of the accused, which we discuss under proviso 4 of subsection 1 of section 497. The 10th one is the court has to consider while dealing with bail application an opportunity to the accused to prepare his case. The 11th one is if the accused is already in the jail for a considerable period and the trial is not likely to conclude in near future, which we discuss under proviso 3 of subsection 1. The 12th one is the bail not to be withheld is a punishment to the accused and may be allowed in appropriate cases. Now, in prohibitory clause of this section, the court has to consider following factors while deciding bail application in case of offences punishable with death, imprisonment for life, or imprisonment for 10 years. The court has to determine benefit of reasonable doubt while deciding bail application. Benefit of reasonable doubt always goes to the accused. Benefit of reasonable doubt about occurrence itself, about identity of the accused, about part played by the accused in the occurrence, about the presence of the accused at the spot, about all the questions of vicarious liability of the accused? In short, benefit of reasonable doubt about all these things would always go to the accused and he may be released on bail. The court has to consider all the allegations mentioned in FIR against the accused, statement of the prosecution witnesses recorded under section 161, all the incriminating materials collected by the prosecution against the accused, any plea raised by the accused. All these are the factors which the court has to consider while granting bail in the offences falling under the prohibitory clause of this section. Now come to Proviso 3A of subsection 1. When a person who is accused of any offence not punishable with death and who has been detained for a continuous period, which you can see on the screen, and whose trial has not been concluded, he or she shall be released on bail. If the accused is a man and his detention in the jail exceeding 1 year, and if the accused is a woman, her detention in the jail exceeding 6 months. But the important thing is that he or she shall not be so released if the delay in the trial was occasioned by an act or omission of the accused or by any other person on his behalf. Now come to Proviso 3B of subsection 1. When a person who is accused of any offence punishable with death and who has been detained for a continuous period, which you can see on the screen, and whose trial has not been concluded, he or she shall be released on bail. If the accused is a man and his detention in the jail exceeding 2 years, if the accused is a woman and her detention in the jail exceeding 1 year, but he shall not be so released if the delay in the trial was occasioned by an act or omission of the accused or by any other person on his behalf. Now come to Proviso 4 of subsection 1. Under this proviso, we discuss the character of the accused, and the bail shall not be granted under Proviso 3, which we have just discussed, to a previously convicted offender for an offence punishable with death or imprisonment for life, to a hardened, desperate and dangerous criminal, to a person who is accused of an act of terrorism punishable with death or imprisonment for life. It means that the bail is not to be granted to these persons even if their detention in jail is exceeding the periods specified in Proviso 3. Now come to second proviso of subsection 1. Under this section 497, a person accused shall not be so released until and unless the prosecution has been given notice to show cause why the accused should not be so released. Now come to subsection 3 of this section. It is the duty of the court to record in writing the reason of granting bail to the accused under subsection 1 and subsection 2. Who can grant bail under section 497? Officer in charge of police station can grant bail under section 497 and the other sections you can see on the screen. But practically he does not grant bail under this section 497 because he will have to record reason for grant of bail and to give notice to the prosecution, which he can't. Courts have power to grant bail under section 497 and all the other sections you can see on the screen. Court of Sessions has power to grant bail under section 497 of CrPC. High Court has also power to grant bail under section 497 of CrPC.